Under the Securities Act of 1933, we have Rule 153A. Once again, you don't have to know what does it do, it's just that's what it's called. Prospectus delivery requirements. The definition of preceded by a prospectus in relation to certain transactions that require the approval of security holders. The term preceded by a prospectus has to do with Rule 145, the reclassification of securities when there's a merger, consolidation, or acquisition of assets. So there's this requirement for the delivery of a prospectus. When? So it's a very interesting rule to have on the outline, but I have to include it in your information if it's on the outline. So the delivery, so oftentimes we talk about the delivery of a prospectus whenever you sell a new issue. But this is the reclassification of securities when there is a merger or consolidation or acquisition of assets. When does the prospectus have to be given? Prior to the vote of security holders on such transactions, or with respect to actions taken by consent prior to the earliest date on which the corporate action may be taken, to all security holders of record of such corporation or other persons entitled to vote on or consent to the proposed transaction at their address of record on the transfer records of the corporation or other person. So if it requires consent, the merger or acquisition, they need to be given a prospectus regarding this prior to the vote, prior to any action that will be taken. So the Securities Act of 1933, the Paper Act, the Securities Exchange Act of 34. So one was passed in December, one was passed in January. They're very close together. So the Securities Exchange Act of 34 prohibits the use of manipulative or deceptive devices regarding the sale of securities in the secondary market. Seems fair. The term manipulative, deceptive, or other fraudulent devices or contrivances are defined in the Act to include any act, practice, or course of business which would operate as a fraud or deceit upon any person, as well as the making of any untrue statement of a material fact and any omission to state a material fact necessary in order to make the statements not misleading. Also prohibited are any representations by a broker or dealer that their registration as a broker dealer indicates in any way that the SEC has passed upon or approved their financial standing, business, or conduct, or the merits of any of their securities transactions. The firm is not SEC approved. They might be registered with the SEC. The Act also prohibits any transactions in discretionary accounts that are excessive in size or frequency in view of the financial resources and character of the account. No churning. That's prohibited under the Securities Exchange Act of 34. Broker-dealers that have discretionary power must immediately, after making transactions, make a record of the transaction, indicating the name of the customer, the name, amount, and price of the security, and the date and time when such transaction took place. Immediately record the discretionary transactions. The Securities Exchange Act of 34 also states that it is unlawful for any broker or dealer to make use of the mails or any means or instrumentality of interstate commerce to effect any transaction in or to induce or attempt to induce the purchase or sale of any security unless such broker-dealer is registered with the Securities and Exchange Commission. So just to kind of pull this all together, the Securities Act of 1933, this all had to do with registration of the actual security itself, registration of the security. So the Securities Exchange Act of 34, it actually created the SEC, and it has to do with registration of the persons. So registrations of broker-dealers, registrations of associated persons. So we commonly call the Securities Act of 1933 the Paper Act, and we commonly call the Securities Exchange Act of 34 the People Act. A broker-dealer may be registered by filing with the Commission an application for registration in such form and containing such information and documents concerning such broker or dealer with any person associated with the firm as necessary in order to protect the investing public. We have previously slightly covered this in the course. This is the idea of filing what's called Form BD. So creates the broker-dealer. When Form BD is filed with the SEC within 45 days of the date of filing of such application, the Commission shall grant registration or institute proceedings to determine whether registration should be denied. So Form BD, registration must be granted within 45 days, or they need to institute proceedings saying that registration will be denied. The SEC, by order, shall censure, place limitations on the activities, functions, or operations of, suspend for a period not exceeding 12 months, or revoke the registration of any broker-dealer if it finds that after notice and an opportunity for a hearing that such action is in the public interest, and that a broker-dealer or any person associated with a broker-dealer has done one of these wrong things. So there's this idea that the SEC can embarrass you publicly, censure, place limitations on your activities, suspend you. If you're suspended for a maximum of 12 months, revoke your registration. They have to first give you the opportunity first they give you notice, and then you have the opportunity for a hearing, the ability to defend yourself. It must be in the public interest to take away your license or suspend you for up to 12 months. So if the broker-dealer or any person associated with the broker-dealer has filed a false or misleading application for registration, that would be bad, has been convicted within 10 years preceding the filing of any application for registration, or at any time thereafter, of any felony or misdemeanor involving the purchase or sale of any security, the taking of a false oath, the making of a false report, bribery, perjury, burglary, or any other substantially equivalent activity. So those are all things that the SEC takes very seriously. So this idea, if any person associated with the firm within 10 years has convicted a felony, or the misdemeanor involves the purchase or sale of securities, or at any time someone involved with the firm commits a felony, they could take away the broker-dealer's ability to do business. They probably won't, but they could. And they could definitely take away the registered representative's license. Granted, we talked about some of the rules in one of the earlier sections regarding statutory disqualification. If a broker-dealer or any person associated with the broker-dealer is permanently or temporarily enjoined by a court from engaging in the securities business, well, then they can't engage in the business, has willfully violated any provision of federal securities law. Much better to have unknowingly violated federal securities law than it is to have willfully violated federal securities law. If the broker-dealer or any associated person is subject to an order of the Commission barring or suspending the right of the person to be associated with the broker-dealer, or is subject to any final order of a state securities commission, a state authority that supervises banks, savings associations, or credit unions, a state insurance commission, or a federal banking agency that bars such person from engaging in their regulated activities due to fraudulent, manipulative, or deceptive conduct. So can the SEC use a registered representative's revocation of their insurance license against them? Absolutely yes. No registered broker-dealer shall effect any transaction in or induce the purchase or sale of any security unless such broker-dealer meets the standards of operational capability and meets the standards of training, experience, competence, and such other qualifications as the Commission finds necessary or appropriate in the public interest or for the protection of investors. Section 35 of the Investment Company Act of 1940 addresses unlawful representations and names. Generally, it is unlawful for any person selling any security of which a registered investment company is the issuer to represent or imply in any manner that such security has been guaranteed, sponsored, recommended, or approved by the United States or any agency, instrumentality, or officer of the United States, has been insured by the FDIC, or is guaranteed by or is otherwise an obligation of any bank or insured depository institution. Further, any person selling the securities of a registered investment company that is advised by or sold through a bank shall prominently disclose that investment company is not insured by the FDIC or any other government agency. So the concern is that when the client buys shares of a mutual fund on the premises of a bank, that they might be confused with a retail deposit that they could make at the bank. So of course it must be disclosed that investment in this mutual fund is not insured by the FDIC or any other government agency. It is unlawful for any person registered under this act to represent or imply in any manner that they have been sponsored, recommended, or approved, or that their abilities or qualifications have in any respect been passed upon by any agency of the United States. However, no provision of the Investment Company Act of 1940 shall prohibit a statement that a person or security is registered if such statement is in fact true, and if the effect of such registration is not misrepresented. So if a security is registered, then you can say that it's registered. You just can't say that it is approved. If you are registered, you can say you are registered, but you are never approved. It is also unlawful for any registered investment company to adopt as part of its name or title any words that are materially deceptive or misleading. Back to some more FINRA NASD conduct rules. FINRA Rule 2320 has to do with variable contracts of an insurance company. No member firm shall participate in the offering or in the sale of a variable contract on any basis other than at a value to be determined following the receipt of payment in accordance with the terms of the contract, the prospectus, and the Investment Company Act of 1940. So this idea, it's a similar concept that we have in mutual funds, that it's always forward pricing, variable annuities, variable life insurance, so a value determined following the receipt of payment. Payment need not be considered as received until the contract application has been accepted by the insurance company. So that is important, except that by mutual agreement it may be considered to have been received for the risk of the purchaser when actually received. Every member firm who receives applications and or purchase payments for variable contracts shall transmit promptly to the issuer all such applications and at least that portion of the purchase payment required to be credited to the contract. So if you collect monies for a variable life insurance policy, when should you forward it on to the issuer? Promptly, of course. No member firm who is a principal underwriter may sell variable contracts through another broker-dealer unless such broker-dealer is a member firm and there is a sales agreement in effect between the parties. Such sales agreements must provide that the sales commission be returned to the issuing insurance company if the variable contract is tendered for redemption within 7 business days after acceptance of the application. So sales commissions on variable products must be returned if the contract is tendered for redemption within 7 business days after acceptance of the application. Within 7 business days. So nobody can collect a commission if the client basically wants out of the contract within 7 days of acceptance of the application. So it's a chargeback on your commission. Sales commission must be returned to the issuing insurance company. Definitely on your test. No member shall participate in the offering or in the sale of a variable contract unless the insurance company, upon request of a request for partial or total redemption, promises to make prompt payment of the amount requested. So you shall not participate in an offering unless the insurance company promises if your client wants a partial or full redemption, they should get it promptly. So make prompt payment of the amount requested. That seems fair. In connection with the sale and distribution of a variable contract, no associated person of a member firm shall accept any compensation from anyone other than the member with which the person is associated. However, this does not prohibit arrangements where a non-member company pays compensation directly to an associated person, provided that the agreement is agreed to by the member, such compensation is treated as compensation received by the member, and record-keeping requirements are satisfied. No member firm or person associated with a member shall accept any non-cash compensation except for the following, which are permitted. Gifts that do not exceed $100 per person per year and are not preconditioned on achievement of a sales target. An occasional meal, ticket to a sporting event or the theater, or comparable entertainment which is neither so frequent nor so extensive as to raise any question of propriety and is not preconditioned on the achievement of a sales target. So a ticket to the theater, not season tickets to the theater. What else is permitted? Payment or reimbursement by offerers in connection with meetings held by an offerer or by a member for the purpose of training or education of associated persons of a member, provided that proper records are kept, that the associated person's attendance is not preconditioned on the achievement of a sales target, the location of the meeting is appropriate distance-wise from the associated person's office. So we're not going to have the meeting in Hawaii just because that sounds like fun, unless we live in Hawaii, and then that'd be fine. And payments are not applied to the expenses of a guest of the associated person. So can the offerer pay for me to go attend a meeting related to the products that they would like me to sell? Certainly, a training meeting. Can they pay for my husband to come along with me? No, they cannot. Can he come if I pay for him myself? Yes. Non-cash compensation arrangements between a member and its associated persons are also permitted, provided that the arrangement, if it includes variable contract securities, is based upon the total production of associated persons with respect to all variable contracts distributed by the member firm, and the credit received for each variable contract security is equally weighted. So sometimes referred to as the sales contest rules. So there's this idea, let's say that I'm a registered rep at a broker-dealer and we have 5 different insurance company products that we sell. It can't be that there's a contest to get the most dollars into insurance company A's variable products. That would be prohibited. What would be allowable, though, would be a sales contest based upon total production of all of the variable contracts with equal weighting given for each one that was sold, no matter which one was sold. So what has happened historically is we have found some broker-dealers will invent their own proprietary funds and then try to get all of their clients to switch and put all of their dollars into the proprietary funds. And then they have these sales contests related to doing that. That would be prohibited. You have to follow this rule. Total production, equal weighting. NASD Rule 2420, dealing with non-members. No member firm shall deal with any non-member broker or dealer except at the same prices, for the same commissions or fees, and on the same terms and conditions as are by such member afforded to the general public. So if you're dealing with a non-member broker dealer, they must be treated as the general public would be treated. Further, no member in any transaction with a non-member broker dealer may allow a non-member any selling concession, discount, or other allowance, join with any non-member broker or dealer in any syndicate or group in distributing to the public any issue of securities, or sell any securities to or buy any security from any non-member broker or dealer, except at the same price such member would buy and sell such security from the, who do you think? General public. So non-members are treated as the general public. NASD Rule 2830 has to do with investment company securities and sales charges. NASD rule. This is going to require some charts. Investment company securities. So mutual funds, basically. No member firm who is an underwriter of the securities of an investment company shall sell any such security to any dealer or broker at any price other than the public offering price, unless a sales agreement is in effect between the parties which sets forth the concessions to be received by the broker or dealer. No member firm shall offer or sell shares of any investment company if the sales charges described in the prospectus are excessive. Aggregate total sales charges shall be deemed excessive if they do not conform to the following provisions. So we have to keep track of these. Now, the basic rule is the rule that we're already comfortable with. That's a rule that says the maximum sales charge allowed on an open-end mutual fund is 8.5% of the ask. That's true. Maximum sales charge allowed is 8.5% of the ask. There's a couple of things, however, that must be true in order for this to be a possible sales charge. Now, generally speaking, there is no, funds don't do this. They could do this, but they don't do this. You still need to know what they could be. How high could they be? Competition, of course, has brought down the sales charges. So in order for a fund to charge the maximum sales charge allowed, 8.5% of the ask, there can be no 12B1 fee. A 12B1 fee is that asset-based distribution fee. No 12B1 fee. There can be no service charge on the account. So a service charge is like a maintenance charge, a handling charge. So these are two things that there cannot be. And then these are things that must happen in order for the fund to charge the maximum sales charge. Automatic reinvestments of income distributions, that's the dividend and capital gain, without a sales charge. So another way of saying that is at NAV, so without a sales charge, at NAV per share. They must also have schedules of breakpoints, which are for large lump sum purchases, and they must also offer the right of accumulation. So all of these things, these three things must be true. These three things must be true, and these two things cannot be true. They cannot charge a 12B1 fee, and they cannot have a service charge. So that's the maximum sales charge that is allowed. Now, if there is no 12B1 fee, if there is no service charge, they allow the automatic reinvestment without a sales charge and they allow breakpoints, but they don't allow the right of accumulation, then the maximum sales charge allowed is 8%. Then the maximum sales charge allowed, if they do not offer the right of accumulation, is 8%. What else is in this NASD rule? When the fund offers breakpoints, or they offer the right of accumulation. So breakpoints are for large lump sum investments. The right of accumulation recognizes that not everybody has a lot, but that over time they might have a balance that is over a breakpoint, so that we allow them a reduced sales charge over time. So this idea of the right of accumulation shall mean a scale of reducing sales charges in which the sales charge applicable to the securities being purchased is based upon the aggregate quantity of securities previously purchased and then owned plus the securities being purchased. Now, when we're looking at an aggregate right of accumulation, the quantity of securities owned shall be based upon the current value of the securities or the total purchase of such securities at actual offering prices or the higher of the current value or the total purchases. So it's this idea of if you put in more than what they are currently worth plus what you're investing today, if it gets you over a break point. So if it's current value plus what you're investing gets you over a break point, or what you had originally invested, so at the ask price, if you will, plus what you're investing, whatever one's higher, that's what we use to determine the right of accumulation. The quantity of securities owned may also include redeemable securities of other investment companies having the same principal underwriter. So sometimes there's the same principal underwriter for more than one investment company. And it's also true that within a family of funds, your client might have some money in the growth fund and some in the income fund. They can combine those purchases for the right of accumulation as well. So if the fund offers breakpoints or the right of accumulation, this is the worst that they can set up their sales charges to be. The fund can always have lower sales charges. That's true no matter what we say. So one of these two. Purchases of $10,000 to $24,999, 7.75%. So there's two here, one or two. So 10,000 to 24. So whether or not it's a break point or the right of accumulation, it wouldn't matter. If this was the initial purchase or the cumulative of the purchases plus what you're currently purchasing, the maximum sales charge, 7.75. $25,000 or more, 25,000 or more, then the maximum sales charge, 6.25. So they can choose to follow that one, or they can choose to follow this one, which says purchases of 15,000, so this is a higher break point, 15,000 to 24,999 up to 7.5 maximum sales charge, 7.5, 25,000 or more, same, 6.25. So that one might take some practice. So when it has a lower break point, we allow a higher sales charge. The higher break point has the lower sales charge. Can always be less than that, that's true.